All right, we are live. This is Matthew Newsom, attorney for Surge Business Law, and this is the first Ask Me Anything live stream for December. We have some excellent questions lined up for today. First of all, I do want to say that I am not your lawyer, and so this cannot be construed as legal advice. Please, if you see any of this information and would like to know more about how it applies to you, please contact me. I would love to give you a legal advice, but this is the internet, and so take everything with a grain of salt. I have tried hard to make sure that these questions are not too specific to any one use case, to focus on generalities. All right, let's go to the first question. What are the different entity types available to small businesses? This was sent to me via a YouTube commenter, and so please comment on my videos. I would love to include your questions in my future Ask Me Anything live streams. So really, there are four types of entities available to a small business. First of all is a sole proprietorship. So if you go to the end of your driveway and you put up a lemonade stand and start selling lemonade, then you are a sole proprietorship. Sole proprietorships have no limits on liability. And so that means if you screw something up and a person is harmed because of that, they can go after you personally. There is also a partnership. A partnership also requires no registration. Two people or more who agree to go into business together, they can have a handshake agreement, a verbal agreement, whatever. As soon as one of them starts to take action, then they have created a partnership. However, and partnerships like that are unlimited liability partnerships, which means you can get sued for your own actions or a partner's actions and be responsible for all of them. However, you can register your partnership so that you can have either a limited partnership or a limited liability partnership. This requires you to create a partnership agreement that has certain protections and then register with the state, much like you would for an LLC or corporation. A limited partnership is a partnership that has two different kinds of partners. For example, full partners, senior partners, whatever, and then limited partners, partners who have a less authority and therefore less responsibility. And so limited partners can avoid the unlimited liability because they have less power. And then a limited liability partnership is very similar to an LLC. The next thing, the third one that we talk about for small businesses are LLCs or limited liability companies. These are the most popular form of business entity for small business nowadays because they provide three things that businesses really like. First of all, they are simple. Second of all, they are easy to create. And then third, they provide limited liability. Now, a lot of people, they go and create their LLC and they forget that the goal is that third option, the limited liability part. And so if you do things wrong and you set up your LLC incorrectly, you don't get the LL, the limited liability part. And the three steps that you need to follow to get the limited liability is, first of all, you need to register with the state. Second of all, you need an operating agreement that provides the necessary protections for the owners. And then third, you must observe corporate formalities. The corporate formalities are not as stringent as they are for a corporation, but if you don't do them and you get sued, then the party suing you will say that your LLC is not a real business because you haven't treated it like a real business. So those are the three things you must do. Overall, it is very easy. And again, so flexible because that operating agreement that was part two of that, it's a contract and you can put whatever you want in there and it's enforceable, generally speaking. So that means you can do whatever you want. It's like the silly putty of business structures. And then the fourth type is corporations. Corporations are one of the classic. They go back to like the 14 or 1500s. They've been around a long time. Corporations have a lot of laws governing them. They have a lot of regulations and rules and structure that is enforced on them. And this is actually attractive to certain kinds of businesses. If you have investors investing in your business, they're not going to want flexibility or simplicity. They want to make sure that the owners are doing things in a certain way, filing annual reports, having necessary meetings, observing all of these strict processes to protect the investment of the investors. Those are the four types of entities you have available. Some people are going to say, Matt, what about an S Corp? An S Corp is not an entity type. Instead, it is a way of being taxed. And so if you have an LLC or a corporation, you can change your tax structure to be taxed in a different way. And there are benefits to being taxed in an S Corp. And I actually have answered this question. So check out my YouTube, Facebook, or LinkedIn channel, and you will see that I've already created instructions and explanations of S Corps, but I do want to clarify it's so confusing. An S Corp is not an entity, it is a lens that the IRS uses to look at your business. All right, let's do the next question. If you only own one rental property, do you really need an LLC? And this was submitted by Nicole. And the answer is no, you do not. There are benefits to LLCs. The benefit of an LLC is that you can take risks, take chances with your business. And then if something goes wrong, you run out of money, you get sued or whatever, then you can avoid personal liability. And so you, as the owner of the home, of the business, can avoid getting sued for your house or your retirement account. If you have a very simple um, business that is a very low risk situation, then you can probably get by just fine with only having a good insurance policy. And I often tell people if you're only going to do one thing to protect yourself from your business risks, that one thing should be good insurance because that will step in and help you most of the time. However, if your plan is for your real estate holding portfolio to grow over time, then you are going to want to talk to me or another attorney to figure out a strategy for setting up your structure. What happens is that a lot of people, they make decisions about their business when they've got one, two, three properties that makes it difficult to transfer these assets into an LLC later. For example, if you are buying a house on contract or buying a house subject to a mortgage, then you may not be able to easily transfer that property into an LLC unless you pay off the mortgage or contract, which can be a burden. And so therefore, all of your properties that are outside of the LLC do expose you to risk. What we strongly suggest is that if you are going to contemplate a more advanced or complicated real estate portfolio, please talk to me. It is free. We do a free consult for real estate investors to talk about setting up a holding company structure. And it is a lot more affordable and simpler than you think. And as a side benefit, when we set it up for you, we give you significant privacy protection so that your name doesn't get rubber stamped right onto the public records of your real estate portfolio. And that way you don't have tenants showing up at your home in the middle of the night asking you plumbing questions and such. So I do think it's a good idea, but if you only do one thing, have good insurance. Next question. If you own a multifamily property, do you need separate LLCs for each unit? And the answer again is no. And the answer also might be, this might not even be possible. For example, if you have a duplex or a quadplex, you cannot legally divide that up into separate properties that can be pulled out into different LLCs. So in that case, you wouldn't do that. Likewise, if you have an apartment complex, let's say that you have 3 apartment buildings, you might be able to put each separate apartment building into an LLC, but you're not going to be able to do one building in multiple LLCs. But when you're starting to deal with multi-unit properties, you really should be talking to an attorney about setting up a holding company structure. So please talk to me. And here's why. Because what happens is, first of all, multi-unit properties have multiple levels of risk. So if you have a single family house, then yeah, a lot of things can go wrong. But if you have a duplex, well, now you've got twice as many things that can go wrong. If you've got an eightplex, 8 times as many. And so at that point, you're at the point where separating your risks into an LLC becomes more alluring because you might have bigger problems than your insurance will cover. And then likewise, if you have multiple apartment buildings or multiple units, you're going to want to segment them away from each other so that a lawsuit that deals with one cannot affect your real estate that's in the other LLC. So if you have only one multi-unit property like a duplex, you're just going to have it in either one LLC or in your own name. But if you have multiple multi-unit properties, or if your multi-unit property can be divided into multiple legal descriptions, so you have multiple deeds, then yeah, you might want to think about that. Thank you, Nicole. Nicole has another question. It seems that new rentals cannot have gravel driveways. Can existing rentals maintain gravel driveways? And the answer is that it depends. So I'm sorry, Nicole, that's not a very specific answer. But the answer is usually yes, an existing rental may be able to continue maintaining its gravel driveway. This problem comes up pretty often, though, where a person buys a house and it's being used as a rental, but the rental certificate has expired. And typically, if the rules change and the rental certificate or the rental permit lapses, then in order to reapply for a new rental certificate, you are going to have to bring it up to the current code. So if you keep your rental certificate active, then you will usually be grandfathered into the existing the older rules and not be subject to the new rules. This happens sometimes in areas where they have rezoned properties. And so, for example, this year in 2023, twice, believe it or not, two times, I've had a real estate investors come to me because they had bought a house in areas where they had been rezoned, and the houses were more than fourplexes, so 5, 6, 7 units in one building, and the neighborhood now only supported a maximum of either 2 or 4 units per property. And so they had bought let's just say a sixplex, and now they had to convert it down to reduce the number of units. That is a real pain, and there is a legal process for asking them to make an exception for you, and sometimes they do, and sometimes they don't. So in this particular one of these particular cases, the process was going and asking all of the neighbors if they would agree. And guess what? A lot of the neighbors didn't want a sixplex across the street from their house. So it can be quite complicated. So the trick here is not to let your rental certificate lapse. And if you are buying a multi-unit property and you feel that it is not up to current zoning standards, you want to make sure before you close that your rental certificate on that property has not lapsed and can be transferred. Now, I have to say it depends again on this, and I started with that. It depends because different jurisdictions can have different rules. So you might find that this works okay in one county or one town and not in another. And that is just the nature of the beast. Fourth and last question from Nicole. Is there a list of things that will be inspected by the city for a rental certificate? If you don't pass certification, is there any sort of appeals process? This is dependent on the city to determine for you. Now, I got rid of my personal real estate holdings and just moved all of my money into other investments. But the last investment property I owned was in Ankeny. And at the time, Ankeny did hand out a checklist so that you could go through and verify the property for yourself and have your contractor work on it before you would have to have the inspector come out. This is usually a win-win situation because um, the city saves the trouble of having an inspector come out just to tell you, here's all the things that are wrong. So the correct answer here is you should ask your city's rental department for a copy of their thing. Sometimes they have it on the website. Sometimes they'll give it to you if you ask. Maybe they'll say no. And so I think that the common thread I found is that cities that outsource their inspections, they might not have a checklist, and you might struggle to get that beforehand. But in that case, I would talk to a realtor who specializes in rentals in your area, rental properties or investment properties. They might be a good source, but start with the city. Does my employer own the copyright to the content that I create? This was a question that was brought up through LinkedIn, I believe, and I reformatted this question significantly, and the answer is often yes. And so if you hire an employee to create art for you, to create software for you, to write newsletters or magazine articles for you, then that is work for hire. And that means that you are working for your employer, creating this content, and therefore your employer gets the exclusive copyright to that property. Now, this is not true in every country. So this is an American specific answer, and I believe it is also true in Canada. But there are some places in Europe and probably elsewhere where this is not true. So you will need to check with someone local if you are not a US citizen and you're asking this question. But generally speaking, yes, your employer owns the copyright to the things that you create, even if you create them after hours, even if you create them on your own computer. Although when we start to get into those details, we do get to be a little bit less clear and more of a murky area. And so in this case, you're going to want to check with your company's policy. But this is the rule of thumb for copyright questions. If in doubt, ask. And so very often employers will freely grant you permission to make contributions. So I worked for an open source software company. I've actually done that multiple times. And employers would often grant their employees permission to make contributions to the company. In that case, those the organizations who receive those contributions might ask for a contract to be signed from the employer saying that they are okay with this. And that's fine. And I've helped people with those contracts, both in my current law firm and at previous jobs. But that is something that you should probably check into. And another gray area that is not real clear is what happens in situations where you were hired to answer the phones or do something, and then you want to create content that's not at all related to your job. Well, then we start to get to be a less clear situation, and you might actually own the copyright. If you have questions about this, you are free to reach out to me, and you're welcome to even email me, text me, or something along those lines. Hit me up on social media, and I might be able to give you some pointers. And if this is really a big deal to you, you can of course hire me to answer it specifically for your situation. That often requires me to look at any employment agreements that you have with your company and possibly help you develop a strategy of talking to your employer without putting yourself at risk. When is a business actually a business? In this case, the person who was talking to me had said that their hobby had started making money, and so they wanted to know if this is a business. And congratulations, if this is your situation, if your hobby is starting to become profitable, yay. Most hobbies usually are money pits. They suck money away, but once in a while, they are profitable, and that's great. The answer is yes, this is a business. And unless you do something different, this is a sole proprietorship or partnership. But yes, in this case, this is a business. Even if your hobby is not profitable, if you are making money through it, selling products or services, then you might still be considered a business. You might still have an obligation to collect sales tax, and you might still have an obligation to pay some kinds of tax. So, so the answer is that once you start making money, whether it's profitable or not, you're a business, and you probably want to think carefully about what you want to do. The key thing to think about here is what kinds of risks am I exposed to? So for example, is someone's livelihood, is someone's life, is someone's health dependent on the results of this? So there are Good Samaritan laws that allow people to help others and not fear lawsuits. These vary from area to area. But generally speaking, if you are volunteering or if you're responding in an emergency situation, then you have very low risk of being sued for giving bad advice. But if you're getting paid for something, that is a different story. Then if you give someone bad advice and they paid you for it, well, then you might be open to a lawsuit. And so these are why people talk to me. I have very affordable subscription plans for people who have low income side gigs or hobbies or whatever. So it starts at $95 per month. And if you go to my website, go to pricing, I list my prices right there, and you can see how I can help you. Oftentimes creating a simple LLC for your hobby business is a good idea, even if it's a side gig. And we work hard to make sure that we have very, very valuable and low and affordable solutions for people like that. But the answer is yes, you're a business. Yes, you probably have some obligations. Can I use code that I copied from Stack Overflow in my own project? I talked to several people about this recently. One person asked the question, and then I brought it up to others, and people were very surprised by the answer. And the answer is that the software that you copy from Stack Overflow does have an open source license to it, and you might not like it. So here is a bit of a screenshot from the Stack Overflow website. It says, as noted in the terms of service and in the footer of every page, and there's a wink wink, like if you look for it, it's easy to find, it's there. All publicly accessible user contributions are licensed under the Creative Commons Attribution Share Alike license. And depending on when the contribution was made, then a different version of the CC by SA license is used. And so that might make you wonder, what is the CC by SA license? Creative Commons is an organization that makes simple to understand licenses for creators. Now, open source software, there's been numerous open source licenses available for a while. For example, the MIT, the Apache, the GNU GPL license, they are all very, very well-known open source licenses targeted at software contributions. They do not necessarily apply quite as well to other contributions like artwork, prose, text, things like that. The Creative Commons organization created a set of licenses that make it easy for people who create copyrightable things to share them with the world and not have questions. And so the most common license that I've heard of is the CC BY license, which means that if you can use this code for whatever you want, and you just have to give attribution. And so that means if you are creating a mobile app, then on your about page, you just need to say, this includes contributions by, and then list the person who contributed that code to Stack Overflow. But Stack Overflow isn't just CC BY, it is CC BY SA. And here is a summary of that license. And it says, you are free to share, which means copy and redistribute the material in any medium or format for any purpose, even commercially. So good, you can use this even to make money. You are free to adapt. That means you can remix, transform, and build upon the material for any purpose, even commercially. And then, as a greater protection for you, the one who is using this material, the licensor cannot revoke these freedoms as long as you follow the license terms. And the legal license is definitely longer than this, but this summary makes it really easy for the average person to understand. You must do the following two things. You must give appropriate credit by attributing the person who made this and indicate if changes were made. So for example, if you copied some code and changed it and then you used it in yours, fine, you're safe, you can do that. But you must somewhere conspicuous in your program provide attribution. This code uses contributions made by that person and we've changed it. And then also you must share those changes that you make. So if you remix, transform, or build upon the material, you must redistribute your contribution under the same license as the original. So for example, let's say that someone creates a little code that makes an animated GIF, and then you download that code and then change it and use it in certain programs that you make, even commercially, fine. But you need to just say, hey, I'm using code from this person, I've changed it, and then you must make your code available to others so that they can use it as well. And that new code has to be under the CC by SA license. You can't say, you can use it, but you have to pay me. You have to do the CC by A. And then it does say down here, you may not apply legal terms or technologies that legally restrict others from doing the same thing. So this can be quite disconcerting if you haven't ever thought about it, but Stack Overflow code that you use does have an open source license, and it does put requirements upon you. So please, if you have questions about this, I am an open source software lawyer. I've been doing open source since the 1990s. I'm very familiar with it, and I would love to help you to make sure that you and your team are compliant. And it is very, very easy to fall out of compliance when using stuff that comes from Stack Overflow. Can my Snapchats be viewed more than 24 hours after being sent? Now, I added this question because this came up in a conversation with people recently. When you send messages by Snapchat, they get to see the message and then it disappears. Or if they don't look at it within a certain amount of time, it disappears. Well, it's not gone. It's still there. And in fact, I have been in courtrooms and I've seen the shock on people's faces when they thought they had sent a private message to someone and thought it was deleted. And instead, here it is on the projection screen in the courtroom. Nobody's happy when that happens. Nobody likes to see that secret message show up there. Law enforcement can get to your material that you share on Snapchat. So please be careful what you share. Don't think that you can get away with illegal things because Snapchats disappear after a certain amount of time. No, they don't. And if you go look at the privacy policy, which is a very interesting thing to do, you will see that it says, we remove this information right away. Doesn't say when, but then you read a little bit further down and there's this little sentence, but some laws might require us to keep it longer. And yes, that's true. So I believe that it is at least 30 days that law enforcement has to ask, but that information might change and it is not publicly available right now. But the important thing that you need to know is your snaps are not private. Law enforcement, courts can get to them. All right, next question. Can I re-implement some source code that was open sourced so that I can use it without the restrictions of the original license? So this is an excellent question. Imagine that there was an open source software project that you liked and they did something really clever, but the open source license had requirements that you could not comply with. But you didn't want to start from scratch. So you look at the source code to see how it works. Oh, good. Okay. So now, can you go back, close that document out, and then rewrite something from scratch that works in about the same way? And the answer is probably no. Not definitely no, probably no. So once you've looked at something and then you go recreate it, you are probably creating what is called a derivative work. And a derivative work is subject to the copyright of the original creator and the new creator. And so you would have copyright to the things that are specific about your code, but also too, it's possible that the creators of the code that inspired you would also have some copyright over your new creation. And that means that the license might also apply to your code. This is definitely problematic for many people, and so if you're in this situation, I'm very, very sorry, but this is difficult. There is a way around it, and famously, the personal computer era is kind of founded on an example of this happening. So the original IBM PCs were amazing devices, and they used a lot of off-the-shelf components, Intel CPUs, DRAM modules, all of these things that you could buy from an electronics store. But if someone went out and bought all of these pieces and put them together, they wouldn't have a PC because there was a special chip called a BIOS chip that had software that ran on it, and that was kind of the mix master that coordinated all of the different components talking to each other. And the software on that BIOS chip was copyrighted by IBM. And if you didn't have that chip, then your computer would not run software compatible with PCs. Some people downloaded the software off of the chip and created new chips. They just outright copyrighted it. I'm sorry, stole it, and then what's it called? I can't think of the word now. But duplicated it. This is clearly copyright violation, and lawsuits against those people held up. But then a famous company called Compaq, they created their own version of the source code. They never looked at the code from IBM's BIOS chip. Instead, what they did is if I send in this signal, then I get that signal. Okay, then if I send in this signal, then I get that signal. And so they tested every possible combination that they could think of, and then they wrote their own software without having ever seen the original that did the necessary translations, and then they created it into their own BIOS chip. At that point, they could then buy all the components that were in a PC, put them together with their BIOS chip, and sell a PC compatible computer. IBM, of course, sued them and lost. And the court said, they didn't copy the code. They did a black box reengineering of that code. So the difference between looking at someone's source code and re-implementing it is that you have seen that copyrighted content, and so you've kind of been tainted by it. You can't then create a copy that is not a derivative. Versus in this compact scenario, they never looked at the source code. They only looked at the inputs and the outputs, and then they created something new, completely new from scratch that did the same thing. That is a reverse engineering, and that helps you avoid copyright. So sometimes what we have seen people do is they have one person who is not going to make a contribution to the future project, look at the open source software, see what it does, and then tell another person about it without telling them how it works, and then letting them implement a solution. Okay, good, except this is a big problem. Now you might be violating a patent, because algorithms and such can be patented, and they might actually be patented after you copy them. So there might not be a patent available to look at and compare when you do your black box reengineering, but later you might be infringing on someone's patent because it might be in the process, which can be very, very time consuming. So you do have to be careful about doing this. My advice to you is just invent your own stuff or use open source software in a way that is compatible with their licenses. If you need help being compatible with open source licenses, I would love to help you. I would love it. So please call me. What compliance process changes when my company reaches 50 employees, and what should I do to prepare before we reach the 50 mark? And so I just made a couple notes because this is a little bit of a challenging question. And the answer is that there are definitely some compliance situations that do pop up when your company reaches that 50 employee mark. And so I'm just going to go back, rewind what happens before 50. So in Iowa, when you have 4 employees, then Iowa's employment discrimination laws kick in, which is different than the federal discrimination laws, which kick in at when you have 15 employees. So in Iowa, it's 4. Once you do get 15 employees, then you have to deal with pregnancy discrimination, genetic information non-discrimination, Americans with Disabilities Act, and then that's when the federal discrimination laws step in. And you might think, oh, well, if I have less than 4 employees or less than 15 employees, does that mean I can discriminate? It's not a very good strategy. I would suggest not trying. So I strongly suggest having hiring processes to help you be compliant, whether you've got 2 or 200 employees. Once you get to 20 employees, now you have to worry about being compliant with federal age discrimination and COBRA benefits. So age discrimination laws are a very important thing to keep in mind. During the last AMA, people asked, what should I do if I have to terminate an employee who is in a protected class? And my answer at that time was, just presume that everyone that is in your staff is a protected class, because either they are or they will be. So age discrimination, if you are 29 years old now, guess what? You're going to be 40 one day. And that's when age discrimination becomes an issue. So when you have 20, you have to worry about age discrimination. You also have to worry about providing COBRA benefits if you offer benefits, which oftentimes you are at that level. And then also too, in Iowa, you are now subject to Iowa's Mini WARN Act. I'll talk about that in a moment. Then when you get to 50 employees now, you are responsible for providing FMLA, which is the Family Medical Leave Act. There are a couple extra rules that come with FMLA. They have to be within a certain geographic distance, but we'll save that for another conversation. FMLA benefits are something that you're going to have to provide at that level. And then also too, you're going to need to be compliant with the patient protection rules under the Affordable Care Act. And so that can be a hurdle. So if you don't have an HR team, I'm going to get to that in a minute. Then when you get to 100 employees, now you are subject to the federal WARN Act. And so what is the WARN Act, or the Mini WARN Act? If your company is closing a location or terminating more than a certain number or certain percentage of employees, then you must provide certain kinds of notice. And so if you feel like you are going to have to downsize or move one of your locations and it's going to affect the employment of of your company and you have more than 20 employees in Iowa or more than 100 employees federally, then you're going to need to comply with those. And that is a longer discussion, and please talk to me about it. But that is only half of the question. The other half of the question submitted today was, what should I do to prepare before we reach the 50 employee mark? And the answer here is that you need to have solid HR processes. And so that means you need to have a clear HR employee manual. You need to have good hiring processes so that you're not discriminating in your employment practices. You probably need to understand some ideas about making reasonable accommodations for people who have special needs, including mothers who are breastfeeding and need to pump, including employees who need to sit down more frequently. There's numerous things that you want to think about. And so what I want you to do is I want you to talk to me and set up an appointment if you have 20 or more employees to talk about it. One of the things that I'm going to suggest is working with an outsourced HR department, which is a service that you can subscribe to. It tends to be very, very affordable. And so if you have under 100 employees, it is probably more affordable than having your own HR team. And then when you have 100 to say 2 or 250 employees, you probably are going to have an HR person in-house who will then benefit from working with an outsourced HR team, because it'll look like you've got an entire HR department. And so I can help you with making sure that you are compliant and also help you understand the different options available for outsourced HR. So please reach out, because these compliance steps can be quite difficult. So I did work for a federal judge for a while, and she asked me to do research for her employment law cases, because she had formerly been an employment lawyer and frequently did presentations on employment law topics. And so my research for her was studying some of the crazy things that have happened that have landed people in court. And it is so easy to create an environment that subjects your workers to possible discrimination issues, and therefore subjects you, a business owner, to discrimination lawsuits. So let's talk about how to help you stay compliant, because I don't want you to go to court. And that brings me to the wrap up here. And that is, first of all, I want you to subscribe to my Facebook, my YouTube, and my LinkedIn channel. So if you're watching on LinkedIn right now, hit the follow button. Otherwise, or you can connect with me. Otherwise, go to YouTube and follow Surge Business Law, or you can find me on Facebook and follow and subscribe. That way you can see. But also, what I want you to understand is that a lot of people hesitate to talk to a lawyer because they are afraid of the cost. And therefore, instead of talking to me when problems are small and easy to fix, they wait until these problems are big. And I compare, it's easier to put out a candle flame than a dumpster fire. And the way that I help businesses deal with this is I offer very affordable and valuable subscription services, so that anytime you've got a question or problem, you don't have to wait. You just reach out and talk to me or others on my team, and we make sure that your questions are addressed quickly, and then we can put out little fires while they're small, instead of waiting till they get to really, really explosive dumpster fires. So, this is why those employment questions are so important. Please subscribe. Please hire me to be your in-house counsel, and we'll keep your costs low, and we'll keep your list of problems small, and we'll make sure that your legal fees are manageable and affordable. It's been so great talking to you today. I hope that you enjoyed the questions and the answers, and we will see you on the next AMA, which will be in 2 weeks, probably. I think that's December 15th. See you later.